Assalamualaikum warahmatullahi wabarakatuh. Today, our group will present about insurance. My name is Nurul Alia and my group members are Nur Hafiza and Shafatin Admi. Next, the contract requires the contractor to take out insurance against stipulated risks in the execution of the works. The nature of construction works is involving high risk to people and properties. For example, causing injuries to workers, passers-by, damage to the work surrounding buildings and others. The risks carried by the contracting parties are transferred to the insurance companies. The cost of obtaining the policies to be borne by the contractor, for example, the premiums to be paid by the contractor. The SO or architect is advised to inspect such policies to make sure that the contractor complies with the requirements. Importance of insurance. The importance of insurance is to protect the interests of both parties in the contract against claims by injured parties and to minimize the financial risk of the parties as they are passed to the insurers. For example, insurance for a companies. When to provide insurance. The good time to provide insurance is all insurance policies are required to be taken before the works are commenced on site. This is to ensure that the liability of the contractor and the subcontractors are always covered with the necessary insurance. The contractor is not entitled to extension of time due to the delay in depositing the necessary insurance policies with the government. The contractor's employment may be determined if he does not start work within 2 weeks after the date of possession.
PWD 203A Revision 1 2010. Under PWD 203A Revision 1 2010, insurance is stated in few clauses. Contractual provisions regarding insurance is in Clause 14, Clause 15, Clause 16, Clause 17 and Clause 18. Clause 14. Indemnities in respect of personal injuries and damage to property. Clause 14.1. Injury to person and property. Clause 14.1a. In this clause, stated that the contractor shall perform all obligation that has been agreed in the contract at his own risk. The contractor is responsible for any personal injury or death that happen to to the person while performing their work. The government is not entitled to any injury or to death to any person in executing the work. However, the government is responsible if the injury or death is the fault of government and its servant. Clause 14.1b. In this clause stated that the contractor is responsible for any personal injury or death to any person, such as passerby and supplier. The contractor also responsible for any injury or damages to any kind of property, such as neighboring building and vehicles. The contractor is also responsible to indemnify the employer, which is to protect them against claim from third party. However, contractor is not liable if the fault is on the government. Contractor's obligation is to provide protection for government, which will covers the whole contract. Clause 14.1c. Based on this clause, contractor is still responsible for the obligation under this clause, even after the expiry or early termination of this contract. Contractor's responsibility remains the same, even if there is any act did matter or things that happen before the expiration or termination. Clause 14.2. In this clause, stated that the contractor is responsible to indemnify, protect, and defend the government against all action, claims, and liabilities at its own cost and expenses. Government, its agent, and servant are protected by the contractor. Clause 15. Insurance against personal injuries and damage to property. Clause 15.1. Insurance are allowed in the contract as the contractor may be inadequate to fulfill his responsibility to indemnify the employer. Insurance are required to cover contractor if they had a problem such as losses or damages in the ongoing project. This is the period of insurance covering. Clause 15.1a. In this clause, stated that the insurance taken by the contractor is intended to cover the contractor liability to indemnify the government. The insurance policy are required to be taken before the commencement of work. This is because insurance will provide better financial protection for contractors to reinforce their indemnities. However, if the insurance is not enough to pay indemnities, contractors still need to be responsible to it. Clause 15.1b. In this clause, stated that the insurance is required for the purpose of personal injuries or death, damages, or loss to property. Contractors should indemnify the employer in terms of personal injury to or death to any person, such as passerby, supplier, or personnel. Contractor also indemnify for any injury or damages to any kind of property near the site, such as damages to neighboring buildings and vehicles. Damages that occur must be fault of contractor or subcontractor themselves during the commencement of work. This is the information on public liability insurance in Appendix. Clause 15.1c. In this clause, stated that the insurance taken must be the joint name of the employer and the contractor involved. Subcontract work is including under the joint name between employer, contractor, and subcontractor. The clause also stated that the insurance taken must be covered from the date of possession of site until the date of issuance of Certificate of Making Good Defect (CMGD). The insurance must be submitted to the Superintendent Officer (SO) by the contractor before the commencement of work at the site start. This is because the period of insurance is from the day of site possession. Clause 15.2. Based on this clause, stated that whether demanded or not, the contractor shall include the relevant insurance policy and receipt of the premium payment paid to the SO before the commencement of the work. There is no fixed rate because the risk is for each is unique and differ. Different insurance companies will have different rate of insurance and will have several factors that influence the rate, such as limit of indemnities, contract sum, location of the site, and regulation. Next is clause 15.3. In this clause, stated that contractor is responsible to renew the insurance if necessary. For example, if there is extension of time, the contractor shall renew the insurance and the cost should be borne by the contractor. If the contractor did not renew the insurance, the employer or SO may renew the insurance on behalf of the contractor. The employer are entitled to deduct a sum that equivalent to the amount and on-cost charges as stated in Appendix. However, the employer may deduct the cost from performance bond. This is on-cost charges. Clause 15.4 Cancellation of insurance. Clause 15.4e. Based on this clause, the insurance policy can only be cancelled by the contractor within 30 days after the written notice of cancellation has been issued to the employer by the insurer. The cancellation can only be done after the certificate of making good effect is issued to the contractor. The 30 days period given the employer time to take any necessary action before the cancellation of insurance. This is in order to make sure everything is completed by the contractor before the cancellation is done. Clause 15.4b. The government's benefit is to be protected by the Act from any default done by the contractor. Clause 16. Indemnities to government in respect of claims by workmen. Clause 16.1e. The contractor is responsible to compensate the employed workers due to personal injury, death, and accident while working. Contractors are required to compensate according to the Workmen's Compensation Act 1952 and the Employees' Social Security Act 1969. Contractors are required to bear all costs and expenses. Clause 16.1b. The contractors are required to take insurance as a preparation to provide better financial protection against workers' compensation. Contractors is still responsible to compensate the workers even if they fail to indemnify adequately. The insurance policy and the receipt of premium pay are not required to be deposited to the employer. The coverage of the insurance starts from the day of check possession until practical completion. Clause 17. Employees' Social Security Act 1969. Clause 17.1. Registration with SOCSO. Registration with the scheme is compulsory for local workmen in the execution of work. Employers must register their employees in SOCSO scheme even if they already have their own private insurance to cover them from any circumstances. The contractor is required to issue an employer's code number and provide each worker's social security number. Workers that covered under this scheme are only local workers, which are Malaysian and permanent residents earning not more than workers that earn more than 3,000 per month are divided into two. First is workers that have been registered and contribute with SOCSO are compulsory to continue the contribution. even if the wages are exceed 3,000 ringgit per month. Second, the workers that earn exceed 3,000 ringgit per month but previously are not registered or contributed with SOCSO are given an option to be covered under the Act or not. In this clause, stated that the contractor must make monthly contributions to their eligible sector as stated in the Act. The contractor are required to provide SO the statement of contribution or payment voucher as evidence of the contribution for their worker. The contribution must be made from the first time of the employee is employed. Clause 17.3 Contractor must make monthly contribution for all workers. In this clause stated that if contractor fail to pay the contribution, government can retain some money with pay the contribution that is not paid by the contractor. It will include on-cost charges. The payment made by the government for the contribution may then deduct the amount payable to contractor in the interim or final account. The contractor is entitled for on-cost charges as stated in Appendix. The percentage is paid at 5% of the amount of the contribution. Lastly, Clause 18 Insurance of Work. Clause 18.1a The insurance taken by the contractor is needed to be the joint name of the employer and the contractor. The insurance taken by the contractor must insure all the work executed, materials and goods on site against losses and damage by lightning, storm, flood, and etc. The contractor is required to insure the works and materials until the completion of the whole work, despite there is arrangement of sectional completion or partial occupation by the employer. This is the period of insurance covering. Next, clause 18.1b. In these clauses stated that the insurance taken by the contractor must be a company that has been approved by the SO. The contractor are responsible to produce SO the insurance policies and the receipt of the premium payment, even if it is not demanded. Clause 18.2. In this clause stated that if there is necessary, the contractor is responsible to renew the insurance policy, such as an extension of time is granted. The employer may renew the insurance on behalf of the contractor if the contractor did not renew the insurance in time. The employer will recover all expenses from performance bond. Clause 18.3. Based on this clause, stated that the contractor is responsible for any case of losses and damages such as restore, replace, and repair any damages, remove any debris, and proceed with completion of the work. In this clause, stated that work must be proceeded by the contractor even if the insurance claim is not settled yet. All payment made by the insurance company must be made to the employer. Then the employer will pay the contractor for the work done, such as repairing the damages. The payment for contractor is limited only to the amount insured by the insurance company. Contractor will bear the loss if the cost of repair is exceed the amount that compensated by the insurance company.
PAM 2018 Standards Form of Contract. Clause 18. Injury to person or loss or damage of property. In Clause 18.1, it states that contractor is responsible for any physical injuries or death of any employer in the execution of the works. The contractor is responsible for any damage or loss of any real or personal properties in the executing work. Example of indemnity: contractors billing works cause crack to adjoining neighboring properties. Cracks are not considered defect under the contract because no obligation to remedy time. In clauses 18.3 states that the contractor is liable to indemnify for any claim made by the workman under the contract. Payment of compensation under the Workmen's Compensation Act, payment of compensation under the Employee Social Security Act 1969 also. Clauses 18.4 states that the contractor's indemnities under clauses 18.1 to 18.3 shall not be reduced in the event of the negligent contribution by the employer, contractor, and other authorized representative to the damage suffered by any person. Clause 19. Insurance against injury to person and loss and damage of property. Clause 19 is an insurance clause together with Clause 20A on new building purchases by contractor, Clause 20B on new building purchased by employer, Clause 20C on existing building purchased by employer. Clause 19 also required contractor to arrange for insurance to support the indemnity given in 18. Contractor's liability is unlimited. In Clause 19.1 state that contractor is still responsible in this situation if the insurance fails to indemnity adequately. Endorsement is a type of insured party's right to sue to another insured party when both parties are bound to the same contract. There are four types of endorsement, which are employer, contractor, and other party covered by insurance, third parties for any personal injury or property loss on site, take away the subrogation right of the insured, automatic extension or renewal of the insurance. So that the question is, in order to prevent the contractor from a claim caused by themselves from the employer, which type of endorsement should be used to make sure the contractor unable to claim? So the answer is, under clauses 19.1c, it states that this type of endorsement takes away the subrogation right of the insured against the parties named as the insured if the insured was the one that causes the accident to the victims. Clause 19.2. The Employee Social Security Act 1969 is all local workers with monthly wage lower than 3,000 are to be protected. Contractor or employer may be liable for all contributions in the event his movements are not registered under so. Clause 19.3 Contractor and subcontractor to take insurance to cover any local movement not subject to registration under so and get registration before commencement of work. Insurance cover must include claims arising from common law liability, may include a personal accident insurance under Workmen's Compensation Insurance, and lastly, the period of insurance policy coverage is available until the completion date and 3 months after the defect liability period. Clause 19.5 Insurance must be taken from licensed insurance companies approved by the employer. The contractor places with the employer the policies and receipt of the premium paid, with copy extended to the architect and QS. Architect and QS have to check the accuracy of the insurance cover of amount and value, period of insurance, and the for endorsement. If the contractor or subcontractor fail to insure under clause 19.1 or 19.4 are known as breach of contract.
The difference between PWD Form 23A and PAM Contract 2018. Sufficiency of contract documents. PWD Form 23A, SO will issue instruction regarding any discrepancies in the contract document. For PAM Contract 2018, it is not stated. Copies of tender document. For PWD Form 23A, it is not stated, while for PAM Contract 2018, one original signed copy to contractor. Further drawings or details. PWD Form 23A, it is not stated, while for PAM Contract 2018, contractor to request in sufficient time to enable the architect to issue instruction within a period which will not materially delay the progress of the affected works having regard to the completion date. Works Program. For PWD Form 23A, a program of works is not provided by the SO. The contractor shall, within 14 days after the date of the letter of acceptance, contractor must submit it to the SO to get his approval for the work in such forms and details as the SO reasonably determine. While for PAM Contract 2018, standard time period is 21 days from receipt of letter acceptance. Standard requirement is 6 copies unless require more. Shall provide to the architect for his information from time to time. Under both of PWD 23A and PAM 2018 form of contract, they are almost similar in terms of insurance. There are some clauses explain about the insurance based on the situation of contractor and worker in constructions, included foreign workers insurance. Insurance of new buildings or works by the contractor and by the employer also included. There are some types of insurance described in this report based on PWD 23A and PAM 2018 form of contract. The amount need insured and compensation also described based on the cases.